answered throughout our discussion. With respect to the admission, the three questions are, the first is, what is admission? And that has been answered in section 17. The second is, who can make admission? And that is answered by section 18, 19, and 21. Then, against whom it can prove. And against whom it can prove also include that, in what circumstances it cannot be proved, also it itself. And for that, section 21, 22, then by way of amendment, section 22A and section 23, that is no prejudice clause. We have discussed all these sections, and that then we got our answer. Now, today we are scheduled to discuss the few cases that has been assigned in this case material, and along with that there is one case that we left to have discussion. It is on the section 11, the plea of alibi. So first I'm taking this case that is based on the section 11 of the Indian Evidence Act, popularly known as plea of alibi, and then we will discuss cases that are based on this subchapter admission. The case on the plea of alibi is in your case material, and the name of this case is Jayantibhai Bhenkerbhai versus State of Gujarat. So this case is from Gujarat. Jayantibhai Bhenkerbhai versus State of Gujarat, 2002, 8 SCC 165. This is the citation. When you see the case name A versus B, the A is the first party, B is the second party. And in the criminal law, because the offense is not only against the accused, but it is against the society, so the state always remain one of the party. And that's why you will always see that if the offense is committed by A against the B, A murdered B, so the case will be A state versus A, because state has the duty to protect its citizen. So on behalf of this B, the state would be one party to give the justice to the Mr. B. So the securing the punishment is the state duty. So in the criminal case, it is Jayantibhai Bhenkerbhai, the name of this person, and versus State of Gujarat. The first party who approached to the court. So if it is the original case, you will always find state versus A, state versus B, state versus C. And then, it is adversarial system, so the judgment may be in favor of A or may be in favor of the state. So the party who go to the appeal, who will go to the appeal? Who is aggrieved, जिसके खिलाफ judgment है. So अब nomenclature change हो जाएगी. If state was aggrieved, then again state versus A. If A was aggrieved because A was convicted, so A versus state. And then again, in the second appeal, the same thing. So here from the nomenclature, you can feel that this person, Jayantibhai Bhenkerbhai, was convicted. That's why he is in the appeal versus state. And then there written some name, like the year, the name of the journal. Here is 2002. That means the judgment was published. Judgment is not pronounced. The judgment is published in this journal where you can find this judgment. Sometimes, the judgment is, suppose it is, pronounced in 2001, but because it is in the second edition of the journal. So basically this citation is with respect to the place where you can find this judgment, the name of this person, and the journal in it is, here is SCC, Supreme Court Cases. These are the private journal, SCC, AIR, etc. AIR, All India Reporter. So these are the journal. Journal means एक न्यूज़पेपर टाइप से है, जर्नल है, लाइक गैजेट होता है ना गवर्नमेंट का जर्नल. इसमें जो जजमेंट्स हैं वो रहते हैं. एंड देन द नेम ऑफ द कोर्ट इज आल्सो रिटन. सपोज इट इज लाइक SCC, इट इज द सुप्रीम कोर्ट. If it is AIR, so AIR from High Court also, AIR from the Supreme Court also. If it is from Supreme Court AIR, then SC means Supreme Court. Or if it is from High Court of Allahabad, so it is High Court of Allahabad. If it is Delhi High Court, so HD मिलेगा आपको, अलग अलग nomenclature होगा. So here 2002 bracket 8, that means that it is the 2002 8th volume of the SCC, and it is on the page number 165 where this judgment you can find. It is very important because whenever you have to show, whenever the authority, whatever you are saying in that, in sportifying that thing, you have to provide the authority before the court. So where you will find that judgment? So उस समय इसकी कॉपी आप जज को प्रोड्यूस करोगे, देखो सर इसमें पहले ऐसा कहा हुआ है, this is the latest law has been clarified by the court. Okay, so that is citation. ये नीचे वाला citation, ऊपर वाला nomenclature. Okay, with after that we as I told you that every judgment you have to analyze, you have to read with those 5 points. One is the facts, second is the case history, third is the issue, fourth is the arguments, and fifth is the decision. Here the facts are like that. Facts are very simple. गाँव का सीन है, and there is this person Lalji Rajia. So this Lalji Rajia is in the business of selling liquor. काम शराब का ये बेचता है. And to his house, Mr. Singa Magan, he came to his house for getting liquor. दारू के लिए वो आता है. लालजी रानिया was not at home. लालजी रानिया नहीं होता है. His son, minor son, Ashwin was there, and as usual, जो शराबी होता है सिंगा मगन, he asked liquor from Ashwin. अंदर से उसकी वाइफ आती है लालजी रानिया की, and उसनी बेन, और वो मना कर देता है. वो कहता है भाई आपने मना क्यों किया? Then there was the altercation, and it converted into the the argument in abusive language. गाली गलौज होने लगता है. Then next to this लालजी रानिया, उसके और भी भाई बहन बंधु रहते हैं, वो आते हैं और इसको अच्छा लेसन सिखाते हैं सिंगा मगन को. ये इंसिडेंट इज अबाउट 6 to 7 PM, शाम के समय का बात है. तो शाम को सब लोग ड्रिंक करते हैं. सो व्हाट हैपेंड दैट, वहां से तो चला जाता बिकॉज ही इज अलोन, एंड आफ्टर दैट ही केम विद अदर पर्सन्स. So along with 8 more persons, these 9 accused came to the house of Lalji Rania, and then this Lalji Rania was there, and just they start beating him, cause various injuries. If you read para 4, you find that 22 injuries were, out of which 3 incised कटे हुए, and then this person was succumbed to that because of that injury. These injuries were anti-mortem, that means death से पहले की injury cause की गई थी. And if you see some injuries, there were some on the ribs, someone incise कटी हुई थी, and etc. And ultimately because of these injuries, this person was dead. And then the FIR was lodged, etc. These 9 persons, we are not concerned with the name of these 9 persons. So these 9 persons were then arrested, then trial was faced, and these 9 persons were faced the trial. Out of these 9 persons, the 4 persons were accused number 2, 4, 5, 8. They were acquitted. उनको सजा नहीं हुई, benefit of doubt. And 5 persons, 1, 3, 6, 7, 9, they were convicted guilty of committed the offense of murder with section 149. So section 302 / section 149, because they were in the number 5, and as an unlawful assembly with the rioting they came. And then section 149 of the Indian Penal Code, that is the rule of evidence, that every member of unlawful assembly guilty of offence committed in prosecution of common object. So when there is unlawful assembly, 5 or more person, and they with the common object came, so it's not that every person has to cause the murder, has to give the injury. किसी ने एक इंजरी दी, किसी ने दो इंजरी दी. It's not certain by which injury it has been caused, but their common object was to teach the lesson, and in that it has been killed. This person has been killed. So every member of the unlawful assembly is responsible, liable for that. That's section 149. I think you all aware. So under section 302/149, these 5 persons were convicted and 4 were acquitted. 5 को सजा हो गई, 4 फ्री हो गए. Now these 5 persons, because the offense of the murder, the trial is at the session court. Session court में होता है, CRPC में पढ़ोगे. Then on the appeal, these 5 persons went in the appeal to the High Court of Gujarat, and there the High Court dismissed their appeal. That means the High Court has not accepted their appeal. So the judgment of the trial court is as such. Then in the second appeal they have not gone, and the one of the person, this accused 9, whose name is this Jayantibhai Bhenkerbhai, he went to the appeal to the Supreme Court under Article 136, that is special leave petition. He approached, and his story, Kunal is asking, is sir audible? Yes, please answer everyone. Am I audible?
Yes, sir.
Kunal, others are able to hear me, so please check your connection. Maybe there is some problem. Because of this, before 2, there is power failure in my house, and then I was very worried that how to arrange the class. And so when the voice is not coming or the picture is not audible, so it's not an enjoyable lecture. So I can understand that. So you check it. Yeah. So we were there, that his story is that, sir, when the offense was committed, 6-7 बजे तो वो शराब मांगने जाता है, और 8 बजे वो सारा इंसिडेंट होता है. आई वॉज नॉट देयर इन द विलेज. ये घटना जो होती है, दिस इंसिडेंट टुक प्लेस एट विलेज सिंहपुर, तालुक सोनगढ़, गुजरात. उसका कहता है जी, आई वॉज इन एट दैट डे, आई वॉज नॉट इन दैट विलेज, आई वॉज इन द गांधीनगर एंड अहमदाबाद. मैं वहां पे था किसी केस के सिलसिले में, and he produced some evidences also. Now the first question here is, and before going that, on this argument, the issue, so the facts we have learned, the case history we have learned, that how this case reached to the Supreme Court from the session court where this person was convicted, High Court, this appeal was dismissed, and then to the Supreme Court through the Article 136 of Constitution, SLP. The issue was, and that is also written, if you see the case material, you can mark the para also. The para number 1st and 2nd is about the facts. 1st, 2nd, 3rd, and up to the 4th are about the facts of the case, about the injuries. Para number 5 is about the issue. So the issue is that whether this Jayantibhai Bhenkerbhai, in the brief, Jayantibhai, accused appellant, can be held to have participated in the incident of assault as a member of unlawful assembly. Has he participated or not? That's the main question. Okay. Now, with that, the first thing is whether the evidence he want to prove, whether these are relevant or not, that he was not there, he was at Ahmedabad, he has the case of the appeal related to election where he went to the Ahmedabad. There is another case under section 409 of IPC in Viara, all sector. All these things are not related to this case. And so how these can be relevant? He want to adduce it. Okay. Now the question is, section 11 says that what became the relevant when the that fact in connection with the fact in issue or the relevant fact makes certain things is the fact not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact, or if by themselves or in connection with the other facts they make the existence or non-existence of any fact in issue or relevant fact is highly probable or improbable. And so he was not there. He went to the Ahmedabad. He was before the development commissioner hearing the appeal petition. There was another case. All these things, he went to the zoo also. He went to the secretariat in the Gandhinagar because the capital is in the Gandhinagar. वही होगा ना secretariat. All these things are not relevant to the case. Connected ही नहीं भाई, आप कहाँ घूम रहे हैं, हमें क्या मतलब. But because under section 11 they in connection with fact in issue and relevant fact make highly probable and improbable for the existence of fact in issue and or other relevant fact, and so these are made relevant under section 11. Now the question is that to prove his under article section 11 that he was not there, that plea of alibi, what he has adduced. His story is that I'm telling you that on the relevant date where the offense of murder along with section 149 has been committed, 6 July 1989, he was देखो प्रोसिक्यूशन में कितना टाइम लगा, 89 में है और ये अपील 2002 के आसपास की डिसाइड की हुई है. He has the another case in additional development commissioner in Gandhinagar. वहाँ पे एक इलेक्शन पिटीशन थी, and on the same day he has a criminal case under section 409 of IPC. और इलेक्शन पिटीशन वाला जो केस था उसका लॉयर था कांति लाल शाह, एंड व्यारा में जो इसकी केस थी सेक्शन 409 पे उसका इसका एडवोकेट था धनसुख भाई. ओके, एंड बिकॉज बोथ केस आर ऑन द सेम डेट, सो Dhansukh Bhai has informed him before that you have to appear to the Viara magistrate, and then he replied through the postcard that I cannot come because there is another case in before the additional development commissioner in the Gandhinagar, and so he filed the application for non-presence of me. So that thing is also he adduced. Then he said that I was before the additional development commissioner in the with respect to this election petition, and up to 4 p.m. my case was heard in that. After that I went to the zoo और आध पौन घंटा मैं वहाँ भी घूमा. Then I went to the secretariat because I have to meet one Rahul Bhai who was employed as a clerk in the secretariat, and in the secretariat he secured the entry pass for entry. There he has signed his entry is in the register book with the signature, and then he went to his another friend Manik Bhai in Ahmedabad. Gandhinagar Ahmedabad nazdiki hai, and there he stay there, and in the midnight he left from there to his village. शाम के सारे समय इस तरह से. And the incident happened in that 6th July 1989 on the 8th p.m. Now his argument is that because I was not there, and so as the issue that I was not there, so it is highly improbable that I had not participated in the incident of the assault. I was not in that unlawful assembly, and so why prosecution to me? Why the conviction to me? Now the High Court has rejected all this story even by the evidence on the ground. That first thing is that when the in the FIR his name was there, he has not approached promptly on the 7th itself. 7 को आ गया तो उसका जब नाम हुआ तो उसको पुलिस ऑफिसर के पास जाना चाहिए था कि सर आई वाज नॉट देयर विद द एविडेंसेस, तो उसी समय पुलिस ऑफिसर उसका नाम काटते. द सेकंड वाज that it was not fully substantiated in view of non-examination of Dinesh Bhai, who was accompanied the accused in Ahmedabad while boarding the bus of Sogandh, and Rahul Bhai, who were the clerk in the secretariat to whom accused claimed to have gone. That Rahul Bhai and this another person, Dinesh Bhai, whom he claimed to have with boarded the bus, these were not examined. And in light of that, because the burden of the plea of alibi is very heavy, and so the High Court is not satisfied with the plea, and so the appeal was dismissed. Now the Supreme Court said that here there is a certain error committed by the High Court. And the Supreme Court has said that Babulal, who was the public PW, public witness, yani prosecution ka witness 9, investigated officer, he admitted in the cross examination that if road is clear and there is no obstruction, then state transport bus can reach Ahmedabad from Songad village in 8 hours. However, he further admitted that if one has to travel by the state transport bus from Songad to Ahmedabad, then all the state transport buses go to the Ahmedabad from Songad invariably via Surat, which take a longer time also. So 8 घंटा तो निश्चित है कि लगेगा, 8 hours. Okay, and so जब वो अपील वहां पे उसने सुनी है, वहां साइन भी है, he was present there, तो पहले दिन भी यहाँ कम से कम 8 घंटे पहले गया, एंड दूसरे दिन भी वो 8 घंटे बाद में आया. जू में घूमा है नहीं घूमा, we are not sure, we are not certain, but he produced the Jew ticket of that date he was claiming. Second thing is, ये भी बड़ा चालाक, मतलब टिकट भी रखा था, नहीं हम लोग तो फेंक देते हैं उसी समय. सेकंड थिंग इज दैट सेक्रेटरीट में उसके साइन है, एंड देयर इज नो पॉसिबिलिटी टू रिजेक्ट दैट आल्सो. इतना सिंपल नहीं है कि वहां साइन कराओ बैक डेट में सारी चीजें, इट्स नॉट सो सिंपल. एंड ऐसा भी नहीं कि सारी चीजें इतना कैलकुलेटेड मैनर से हो रही है. सो फर्स्ट द सुप्रीम कोर्ट हैज analyze the law on the plea of alibi, that how much burden it has, and then the law was applied in the facts of the case. On the para number 12, you will find that how High Court has rejected the plea. Then on the para number 14, that is also important, where the Kantil also advocate of this Jayantibhai was, his statement was also for the discussion. Then the para number 16 also, and from para number 18 and 19, there is the law related to plea of alibi. So first we have to discuss that law related to plea of alibi. That section 11 as such provides that the facts not otherwise relevant, they became relevant if they are inconsistent with fact in issue or relevant fact. And here if you see, the fact in issue is whether this person, whether the accused causes, the first is the accused causes the fatal injury by that death cause, and third it was with intention. The first question, fact in issue, he causes the fatal injury, that this thinks that he was not present here, that is inconsistent. From the second clause also, if you see, that by themselves or in connection with other facts, they make the existence of this causing the fatal injury by the Jayantibhai to this Lalji Ramji is highly improbable, and so under section 11 this is relevant, all these facts that he want to adduce. Then on the para number 19, the law is discussed by the Supreme Court. Some line I want to read, that alibi is not an exception, special or general in vices in Indian Penal Code or any other law. It is only rule of evidence. So ये exception नहीं है This is rule of evidence recognized in section 11 of the Evidence Act, that facts which are inconsistent with fact in issue are relevant. The burden of proving the commission of offense by the accused so as to fasten the liability of guilt on him remains on the prosecution and would not be lessened by the accused, would not be lessened by the mere fact that accused had adopted the defense of alibi. The plea of alibi taken by the accused need to be discharged only when the burden lies on the prosecution has been discharged satisfactorily. So here the Supreme Court is observing that how the things will follow. There are two sections, and the two important terminology are, one is the burden of proof and another is the onus of proof. Burden of proof is under section 101 of Indian Evidence Act, and the onus of proof is section 103 of the Indian Evidence Act. The question is that who will prove the case? So section 101 said that who went to the court and want relief in his favor. अब यहाँ पे कोर्ट में कौन गया था? State. So the prosecution has to prove, and when the prosecution has satisfactorily has proved his burden, yani all three facts in issue, the accused caused the injuries, by that injury the death was caused, it was through the medical examination कि ये injury थी, इससे death cause हुई, हो सकती कि नहीं, that can be ruled out or not. And the third is that these injury caused with intention to cause the death, or whatever in the section 299 read with section 300, the three clauses also. So this is the burden, and when it is satisfied, then comes to the onus of proof. Onus of proof, if you read section 103, it not say the onus of the proof, the special fact that is in the knowledge of the person, then the burden is on the person who claim the court to be proved. Here Jayantibhai के knowledge में है कि he was not there, he was in the Ahmedabad, and so it is Jayantibhai burden, it is Jayantibhai onus to prove these things. And ये जो onus है plea of alibi का, this will start after the prosecution has first satisfiedly proved his prosecution case. So if the prosecution has failed in discharging its burden of proving the commission of crime by the accused beyond any reasonable doubt, it may not necessary to go into the question whether the accused has succeeded in proving the defense of alibi or not. An obligation is cast on the court to weigh the scale of evidence adduced by the prosecution in proving the guilt of the accused and the evidence adduced by the accused in proving the defense of alibi. The burden of accused is undoubtedly heavy, as it is observed by the High Court. This flows from the section 103 of the Evidence Act, which provides that the burden of proof as to any particular fact lies on the person who wishes the court to believe its existence. However, while waiving the prosecution case and the defense case pitted against each other, if the balance tilt in favor of the accused, the prosecution will fail and the accused would be entitled to the benefit of that reasonable doubt which would emerge in the mind of the court. So the question of the plea of alibi or the burden of plea of alibi has to be examined when first the prosecution has to pass this test of satisfactorily satisfying his duty, and after that the defense has to prove his plea of alibi, though the burden is heavy. But when this defense arguments and the prosecution case both are pitted against each other, and the balance, or you can say there is something in favor of the accused, then the court has to tilt in favor of the accused and say that the prosecution has failed to prove his case beyond the reasonable doubt and the benefit has to be given to the accused. Okay. Para 20, that reverting back to this fact and circumstances of this case, now the court is applying this law into the facts of this case. The nature of the accusation made against the accused appellant, waiving the same against the overwhelming defense evidence adduced by the accused appellant in support of his plea of alibi, in our opinion, reasonable doubt is created by the prosecution case so far as the participation of this accused appellant incident is concerned. Supreme Court is saying that if we analyze the plea that taken by the defense, he is satisfactorily created the doubt in the mind of the court. We have already noted the High Court itself having that arrived at a finding in favor of the accused that his presence was Gandhinagar up to 11 a.m. on the date of the incident cannot be doubted. That being so, it rendered highly improbable if the accused appellant could have reached back to village Shankpur by the time the incident happened. For the foregoing reasons, we are of the opinion that the accused appellant is entitled to the benefit of doubt and his appeal therefore deserve to be allowed. Other things were also observed throughout the case. You will find that there is no, there is nothing to show that how to disbelieve on the evidence produced by the accused on the signature signed in the secretariat office. But if leaving all these things, अगर वो 11 बजे तक भी था, and the prosecution thing is the PW witness ने एग्जामिन किया कि वहां से 8 घंटा लगता है स्टेट ट्रांसपोर्ट बस से करे, एंड अगर सूरत के वाया आएगी तो टाइम और भी ज्यादा लगेगा. अगर 11-12 भी मानते हैं तो भी 8 बजे तक वो नहीं पहुंचेगा. 11 मानते 8 घंटा वो बचाया 7 बजे और सूरत के से और ज्यादा टाइम लगेगा, तब भी वो 8 बजे तक वो नहीं पहुंच पाएगा. So that is the thing. But if you see that all the other evidences also there, that his case finished at 4 p.m. But the Supreme Court at the extreme level said that even undoubtedly, if you presume in the High Court that 11 tak to thai presence to thi, because there is the that signature in that case of the election petition, then also it's not possible, it's highly improbable that he has reached to the incident where this murder happened at 8 p.m. in the night. And so with that, the defense has successfully created the doubt and the appeal was allowed. Now, after allowing the appeal, see the fate of the case. 4 persons remain because 5 out of 9, 4 were acquitted, 5 were convicted. And out of 5, the Supreme Court has acquitted Jayantibhai also. Now remaining are 4. So section 149 cannot apply because for section 149 along with section 141, the 5 person has to be there. Ab 4 person ho gaye, so section 49 will not apply. And so in para number 22, you will find it. But because these persons have not filed, this, because on every, section, the punishment would there. Section 302 की punishment होगी, section 149 की भी punishment होगी, whatever be there, the offenses जो भी लगे होंगे. But if the court say that the punishment generally it is concurrent, so court will write it is concurrently, so साथ चलेंगी, consecutively, one after one after. So suppose the 2 punishment, 1 for offense 1 year for offense 1 year for offense 2, and they are running concurrently, so एक ही साल में दोनों का काम हो जाएगा, क्योंकि एक आदमी है तो 2 अलग अलग के लिए थोड़ी होगा. बट ये कंजिक्यूटिवली होंगी, तो पहले एक की 1 साल पूरी करनी पड़ेगी, फिर दूसरे की 2 साल पूरी. एंड सो इन दैट वे it will take into 2 years. So here if you read first para, you will find that the punishment are concurrently run, etc. And then Supreme Court said that under section 149 it failed, yet the non-appealing accused person could still has been liable to the conviction with section 34, because section 34 is again the rule of evidence there, and there the number of the person is 2 that is required. So every person with the common intention, if 2 and 2 or more than 2, they can also be liable under that. Okay, so that is the thing. See, section 34 and 149 are drafted in such a manner. But suppose there are 2 persons and with intention to killing that person, they went to the A. ए के पास गए उसको मारने के इंटेंशन से, और इन दोनों पर्सन में बी एंड सी में सी ने उसके हाथ पकड़े, बी ने उस पर मारता रहा. नाउ द इंजरी इज काज बाय बी. अब सी कहता है कि नहीं मैंने तो कुछ नहीं किया सर, मैंने तो हाथ पकड़े थे. इट्स नॉट that by hand, but section 34 create that rule of evidence that with the common intention they did. And similarly the section 149, if they are in the unlawful assembly with the intention to do any illegal, in 141 you will find various clauses that create an assembly to the unlawful assembly. So section 149, every person, whether he has done or not, small काम क्या नहीं, when the member of the unlawful assembly committed in the common object, every person would be like that. Okay, so this is something from your criminal classes, but just to clarify, I have explained it. Now with that, the Supreme Court said that section 149 is removed, and section 34 would be implement in place of section 149. So with that, the appeal has been allowed in the Jayantibhai case, and the issue that whether he participated in the assault or not, the Supreme Court decided that he has not participated because he has satisfactorily created the doubt under section 11 of the Indian Evidence Act. This is the end of this case. Now, if you have any question, any doubt with respect to section 11 or with respect to this case, you can ask me. I'm giving 1 minute. Now, then we will approach to the another case, second case. Yes, Mr. Akash Singh. Akash.
सर
कुछ पूछना है, कुछ सब कुछ समझ में आया?
यस सर.
Any doubt, etc.?
No.
Okay, so we can approach to the another, because it's not to take the feedback of every person. एक से पूछ लिया होता है ना, राइस को कुक कैसे करते, तो एक राइस निकालते हैं, सारे राइस थोड़ी देखते हैं. को समझ. So when one has understood, so I presume that all you got, but after that also, if you have any problem, you can ask me in the next classes also. Now the second case I'm taking, and this case now all the cases will be on the admission. The second case and the judgment is written by V.R. Krishna Iyer. Bishwanath Prasad versus Dwarka Prasad. Bishwanath Prasad versus Dwarka Prasad. AIR 1974 SC 117. AIR means it is in All India Reporter Journal, and कौन से ईयर का पब्लिकेशन है? 1974 का, 1974 का, सुप्रीम कोर्ट वाले जजमेंट का, और 117 नंबर पेज पे ये केस आपको मिलेगा. This the citation is for that, where you can find. Now this is civil case, Bishwanath Prasad versus Dwarka Prasad. Name of the two person is written, and here the facts are like this, that there is the suit filed by the the plaintiff, and there are some pro forma defendant also. What is the pro forma defendant? That who should be in the favor of the plaintiff, but because they are not there, so unko pro forma defendant bolte hain. In the CRPC you will read it in the clear. Suppose like thoda sa mujhe time do. Suppose you are 5 brother, 1 2 3 4 5, and you have one property, and on that property some Mr. X encroach करता है या और उस पे कब्जा कर लेता है, and then you file the case. So this case cannot be decided with the participation of these persons. Okay, because आज आप ये हो गया, कल को फिर ये आएगा, परसों को फिर ये आएगा, फिर ये आएगा, ये आएगा, and so और ये आपके साथ भी नहीं मिलना चाहते, आपकी बड़ी दुश्मनी हो रखी भाइयों से. So along with this X, you also made these 4 person as a defendant, but these 4 will be treated as pro forma defendant. So in that cell you can understand by this. So there is a suit filed by the plaintiff, and there are the defendant, some defendant, and that suit was with respect to the partition. There are two property that were related. One is that soap room at the extreme northwest of the plot number 1238, belonging exclusively to the defendant first party. And second is whether the entire properties mentioned in Schedule C to the plaintiff are joint family property liable to the partition. Okay. Point 2 relate to three items, and then there is one admission by plaintiff ka baap. The uh, with respect to these two issue कि जो शॉप रूम है, जो दुकान है, वो पे किसका हक है, वो डिफेंडेंट से को बिलोंग करती है. प्लेंटिफ कह रहा नहीं मेरी है जी, मेरे को आनी चाहिए. डिफेंडेंट कह रहा है उसको आनी चाहिए. पहला क्वेश्चन तो ये है. सेकंड क्वेश्चन ये है कि जो शेड्यूल सी में जो प्रॉपर्टीज हैं, जो आइटम हैं, वो फैमिली प्रॉपर्टी हैं या किसी की सिंगल प्रॉपर्टी है. अगर फैमिली प्रॉपर्टी है तो पार्टीशन होगा, अगर सिंगल किसी की प्रॉपर्टी है तो नहीं होगा, उसकी सिंगल होगी. This is on the para number first para. You will find these things, two things. Now, जो प्लेंटिफ है उसका फादर होते हैं, और वो फादर साहब यहाँ पे प्रोफॉर्मा डिफेंडेंट है, डिफेंडेंट नंबर 8. एंड there is an admission by the defendant 8 earlier in the title suit number 61 of 1945, and there similar admission made in the written statement filed in that suit by the present 8th defendant, who was first defendant there, 8th defendant, together with the present plaintiff, two of whom were the major at the time. And this admission that this is of defendant number 1 in this plaint. So now you, I think, got that there is Mr. A. He is the plaintiff, and he said that a particular soap should be him in the partition, and the issue framed by the court that whether that soap that is at the extreme corner of that particular plot is exclusively of person B or person A. B ने अपने एविडेंस में कहा कि भाई पहले भी एक ऐसा केस हुआ था, and in that case the name of case is title suit number 61 of 1945. जो A महाशय हैं, इनके फादर साहब ने ये एडमिट किया, और उसकी रिटर्न स्टेटमेंट में भी एडमिट किया कि ये जो सोप है ये डिफेंडेंट की है. और फादर साहब के साथ ये इनके जो ये जनाब हैं प्लेंटिफ और इनके दो भाई उस समय जो माइनर हुआ करते थे, इन्होंने भी ये एडमिट किया है. एंड सो देयर इज द एडमिशन विद रिगार्ड टू दैट प्रॉपर्टी with respect to the both these questions, that in this particular case on the admission the case was decided. This person was aggrieved कि यार ना कुछ पूछा गया ना दूसरे को एग्जामिन किया गया, एडमिशन के ऊपर सारा मामला सेटल हो गया. So they approached the appeal and finally to the appeal to the Supreme Court. Now before the Supreme Court, on the para number 6 you will find the issue is whether these two properties, whether these two issues can be decided in light of the admission. The arguments from the plaintiff side is that you will find on the para number 6 of this case that in the written statement of this case there is nothing admitted by my side. The second is that admission was not put to me. मुझे तो मेरे पास सामने admission नहीं रखा गया when I was in the witness box, nor his father who was the 8th defendant, nor to the 8th defendant summoned for the examination by the first defendant to give him an opportunity to explain the admission. And therefore the counsel contended that it was seriously harmed by the surprise reliance on the statement attributed to his client without extending a fair opportunity to them to offer their explanation and neutralize the effect of admission. तो काउंसिल कह रहे हैं ना तो इनको एग्जामिन किया गया, ना एट्थ डिफेंडेंट को लाया गया, उनको एग्जामिन किया गया, ना उन्होंने एक्सप्लेन करने का मौका दिया, और इसलिए ये इसी एडमिशन पे रिलाई करके दिस इज हैवी हार्म टू द हिज क्लाइंट plaintiff, and here is the appellant. Now another thing is observed, that suppose there is something that is one give the evidence, then section 145 is also there, that the previous statement is shown to that person to discredit. And here the previous statement, suppose the person plaintiff is saying that this is something, some property belong to me, and this admission you are saying ये previously admitted है, तो ये तो कम से कम उसको दिखाता और उसको फिर वो रिबट करता है, एक्सप्लेन करता, न्यूट्रलाइज करता. And here the question is that what is the value of the admission? And Justice V.R. Krishna Iyer has beautifully discussed and defined the contour, the nuances of admission, and how much reliance it has to be put, how it is different from another piece of the evidence. On the para number 7 and para number 8, you will find that discussion. On the para number 7, that we were not satisfied that there is any substance in the grievance voiced by the counsel. There was no faulty face on the part of the first defendant. And then in the middle of that, indeed, there is no suggestion in the judgment of the High Court that the appellant had even contended about any prejudice to them, or that they had been denied an opportunity to explain the material so used against them. What is more, it is found that at no stage, no subsequent to the High Court decision, either in the memorandum of appeal appended to the application for a certificate or in the statement of the case in this court, he has been pointed out the complaint about the unfair reliance on the admission. The Supreme Court is saying, speaking through Justice V.R. Krishna Iyer, कि हाई कोर्ट के समय या उसके बाद में जो मेमोरेंडम ऑफ अपील ऐसे ही नहीं फाइल होती ना सुप्रीम कोर्ट में, मेमोरेंडम ऑफ अपील एक्सेट्रा, वहां पे कभी ये नहीं कहा कि there is unfairly reliance on the evidence and harm caused to. Now advocate साहब ने बड़ा clearly ये बना के दिया. And then on the para number 8 saying that there is no merit even in the contention that because these three statements had been put to the first appellant when he was in the witness box or the 8th defendant, although he had discreetly kept away from giving evidence, they cannot be used against him. Counsel draw our attention to section 145 of Indian Evidence Act. There is a cardinal distinction between a party who is the author of the prior statement and witness who is examined and is sought to be discredited by use of his prior statement. In the former case, an admission by a party is a substantive evidence. Admission by the party is the substantive evidence if it fulfills the requirement of section 21 of the Evidence Act. And in the testimony, the latter case, the prior statement is used to discredit the credibility of the witness and does not become the substantive evidence. In case of former, that admission, in the former, there is no necessary requirement of the statement containing the admission having to put to the party. There is no requirement कि जो आपने admission किया था past में, वो party के before put किया जाएगा कि now explain it. Because it is an evidence proprio vigor, proprio vigor, proprio vigor, that means the proper evidence, substantive evidence. In latter case, the court cannot be invited to disbelieve a witness on the strength of the prior contradicted statement unless it has been put to him as required by the section 145 of the Evidence Act. This distinction has been clearly brought out. The ruling in the Bharat Singh case in AIR 1966, Supreme Court 405. Court is referring to earlier judgment. And there, a para was quoted by the Supreme Court that admission are substantive evidence by themselves. See, this para is very important. The earlier line that the admission are substantive piece of evidence. They are, evidence in proprio vigor. And now all these 5 6 line, these shows the importance of admission, how much weightage it has to. Admission is substantive evidence. Admission are substantive evidence by themselves in view of section 17 and 21 of the Indian Evidence Act. Though they are not conclusive proof. Conclusive proof is something else. Conclusive proof is something after that there is no need to prove. But substantive evidence means they are important piece of evidence matter. We are of the opinion that admission duly proved are admissible evidence irrespective of whether the party making them appeared in the witness box or not, and whether the party when appearing as witness was confronted with those statements. In case it made a statement contrary to these admission, the purpose of contradicting the witness under section 145 of Evidence Act is very much different from the purpose of proving the admission. Admission is substantive evidence of the fact admitted, while the previous statement used to contradict a witness does not become substantive evidence and merely serve the purpose of throwing doubt on the veracity of the witness. What weight is to be attached to an admission made by a party is matter different from its use as admissible evidence. And so the Supreme Court has clarified the importance of the admission, that admission is the evidence proprio vigor, substantive evidence, and there is no need to put that admission before the party who made it. Under section these are not the earlier statement as required under section 45, that if something you are saying, the earlier statement can be shown to the the person who is deposing the witness, just to discredit, just to check his veracity. The section 145 is like I am deposing before the court that I lived in Ahmedabad. मैं कोर्ट के सामने कह रहा हूँ कि मैं अहमदाबाद में रहता हूँ और उस दिन मैं अपने घर के सामने से गया और इस तरह से मर्डर हुआ. सो द वहाँ का एडवोकेट है, ही कैन शो दैट the earlier ID card or earlier other statement can show that you are living in Delhi. You said that you're living in Delhi. So this 145 allows the the party to show the earlier statement to discredit or to check the veracity. But here the admission is not the earlier statement in that nature. And if that earlier statement under section 145 that is allowed, if that is allowed also, that is not will become an substantive evidence. But the admission is not something that has to put before the person who made it to check its veracity. It is substantive evidence and it is different from the earlier statement as permissible under section 145. So this distinction has been made by the Supreme Court. So with this admission, पहले उन्होंने अपने पैर पे कुल्हाड़ी मार रखी थी, and on that admission both the the issue were decided in favor of the defendant. Appeal was the dismiss in that thing. Okay, so with this case is खत्म कर दिया हमने. Now if you have any question, Manish, just switch off your camera. Manish, your camera is on. Yeah. Any question from this case, Bishwanath Prasad? Yes, guys, please tell me. Bishwanath Prasad versus Dwarka Prasad. Judgment written by Justice V.R. Krishna Ayo, and it is
Sir,
on the yeah.
Sir, what is fatal admission?
हाँ जी.
Fatal admission.
Fatal means something that is dangerous. बाकी इसमें डिफेंस को कुछ प्रूव ही नहीं करना पड़ा ना, सारा एडमिशन उन्होंने किया हुआ है, उन्होंने तो बस वो दिखा दिया. So fatal admission means that is dangerous, that is deadly to the party. So that in that sense it is written as fatal admission. Fatal admission अपने आप में कोई अलग word नहीं है. Admission that became fatal, you can say. Okay.
Thank you, sir.
Now come to the next case, that some part on the section 10 we have already discussed. If you know, Central Bureau of Investigation versus VC Shukla, that is popularly known as Jain Diaries case or the Hawala scam. And it is very unfortunate that this person, Mr. Vinit Narayan, who was the journalist, belonged to the Brijwasi family. He filed, his wife is working in JNU, and he filed the case, PIL case, that there is a certain corruption going on in the government. So hota kya tha puri story, that in the government, in the power sector, बड़े बड़े प्रोजेक्ट होते थे, बड़ी बड़ी प्रोजेक्ट लगाने को, and so these foreigner company want to get the project. So there are some middlemen, three brothers, RK Jain, SK Jain. There were Jain brothers. उनका काम क्या था कि foreigner company हम आपको project दिलाएंगे government से, and we will take money. So there is this government, this foreigner player, and then this middleman Jain. So these Jains, they have to flow the money through the Hawala transaction and then supply to these the person who is the office bearer at that time, the minister and the public servant, all those persons. कुछ सबको ही मिलना चाहिए, ऐसे देश चलता है. So you know that what happened then, the Supreme Court said that CBI directed the CBI to file the case. And in Jain brothers का एक servant भी हुआ करता था, मतलब clerk type से, वो भी Jain था. So Jain साहब भी JK Jain, and this Jain साहब used to live in the South Delhi, जो आपका ये होता है बड़ा ही पॉश सा इलाका है, साकेत में, G36 में. There the police, the CBI read it, and some diaries were found, and in these diaries there were certain entries कि इतना पैसा अडवाणी साहब को, इतना पैसा फलाने साहब को, इतना पैसा VC शुक्ला को, ऐसे there were written. And so the case were filed under the Prevention of the Corruption Act with along with section 120B, that is the punishment of the conspiracy of the Indian Penal Code, etc. And you know, all these things we have already discussed. So these were the facts. The issue was whether VC Shukla and the Advani who were and then the, you know, the case started, charge sheet file हो गई, charges भी frame हो गए, and after the charges, you know, these person VC Shukla and Advani, who are the accused in this case, they approached to the High Court for quashing the charge under section 482, and from there, you know, the High Court quashed, and so the CBI agreed. CBI approached to the Supreme Court. That's why CBI versus VC Shukla. CBI कह रही कि VC शुक्ला को क्यों छोड़ दिया. Okay, that is the nomenclature, you know, says. So आपको बड़े फनी तरीके से बट याद रखना है चीजों को. Nomenclature CBI versus VC Shukla, that means the CBI went to the appeal and it is against the VC Shukla. Now the issue is that these statements, that the entries, certain entries that were recorded in the Jain diaries, whether they can be used, because यही evidences था, बाकी इन Jain brothers की statement थी, उसके servant JK Jain की statement थी, and in light of that, whether these diaries where the amount is written has paid, whether these can be used to prove that there was a conspiracy and all these things. And under section 10, you know, the VC Shukla has successfully said that because there is nothing to show that there is a conspiracy, and for section 10 to prove something that is written, because ये डायरी भी उसी समय लिखी गई जब सारी conspiracy चल रही थी, पैसा का flow था, etc. So for that something has to be proved, that is the prima facie that there is a conspiracy. When under section 10 prima facie evidence is there that there is a conspiracy, then anything said, any act done or written can prove. But as such, you know, only the statement that the Jain brothers no to the VC Shukla, they went on the formal occasion. LK Advani के against तो कोई और भी statement, कोई और statement भी नहीं थी. And so in light of that, there is no prima facie evidence, so section 10 will not apply, and these entries in the Jain diary cannot be used. The another thing that is with regard to the admission, and in this case now we will discuss with these entries in the diaries whether they are admission or not as against the accused JK Jain etc. or against the another accused also. So that we will take. Just give me 1 minute. I just want to switch on my AC. Yes, guys. Yeah. So the issue here is that whether these entries in the Jain diaries are admission or the confession, or can it is be used under the as an admission or as a confession. And there you will find the discussion in this case CBI versus VC Shukla from page number 52 onwards. On the page number, para number 52 onward. On para number 52, the if you read this case earlier, also I said that this case is on the three things. First, that it is on the section 10, section 34, that something written during the transaction or journal transaction, and the last one is on the section 17, that means the admission. Para 52 says that comes to the question whether the entries are admission within the meaning of section 17 of the act so as to the admissible as relevant evidence under section 21, and if so, as against whom can be entries be proved. In section 17, admission has been defended to be the statement oral and documentary, and then section 21 is also discussed. We already have discussed, so there is no point in that. Then there is another important thing, that there must be the difference between the admission and the this confession. And it became very, very important because the word admission has been defined under the section 17, but the word confession has not been the defined. But there are the provision that where the confession would be admissible, where the confession would not be admissible, what thing is done that the confession became admissible. When the confession is not admissible, section 27, what part of it can be admissible, etc. So section 24, 25, 26, 27, etc. are various provisions are there with respect to the confession. And here because the confusion is there because there is no definition. So what amount to the confusion? First time it was clarified in the Privy Council judgment Pakla Narayan Swami versus King Emperor AIR 1939 PC 47, and there the Privy Council said that the confession is something where the accused or where the person admit in term of the offense, that suppose it is the rape, I have raped, it is the murder, I have murdered, or at any rate substantially all fact which constitute the offense. So suppose it is the case of murder, so all the fact that constitute that yes, I caused the injury, yes, there was an intention. both things is admitted, then also it would amount to the confession. But an admission of but you know an admission of gravely incriminating fact, even conclusively incriminating fact, or is not in itself is a confession. But admission of incriminating fact, like the murder was committed by the knife, and you admit that yes, this knife is mine, or there is something that shows that other person cannot be in the house, then also this admission would not be confession. This is remain only the admission. It is not confession, because you have not either admitted offense itself or all the constituent, that all the fact that constitute the offense of the murder. And so in this para number 56 on the para number 52, page number 56, you will find this. And so an admission of gravely incriminating fact, even a conclusively incriminating fact, is not itself the confession. And then the example as I have given is explained, that an admission that accused is the owner and was of recent possession of knife or revolver which caused the death, with no explanation of any other man possession, is not the confession. And later on also, the Palvinder and other cases, it has been said that this is the meaning of the confession. Now come to the that Money law of evidence, that it has seen that only voluntary and direct acknowledgement of guilt is a confession, but when the confession falls short of actual admission of guilt, it may nevertheless be used as evidence against the person who made it or his authorized agent as an admission under section 11. The law in this regard has been clearly, in our considered view, correctly by the Munir law of evidence, that the distinction between admission and confession is of the considerable importance. Firstly, a statement made by the accused person, if it is an admission, it is admissible under section 21 of the Evidence Act, unless the statement amount to a confession was made to the person in authority in consequence of some improper inducement, threat, or promise, was made to the public officer, or was made at a time when the accused was in the custody of police officer. If a statement was made by the accused in the circumstance just mentioned, its admissibility will depend on the determination of the question whether it does not amount to the confession, it will be inadmissible. Section 24 situation it is saying. And here the question is whether this statement or these entries would constitute the admission, or whether it would constitute the word confession. And there, in the para number 55, Mr. Altaf Ahmed, the entries which are statement as held by the Bhogilal are being admission and not confession cannot be used against Sri Alke Advani and Sri Shukla, because admission are used against the person who makes them, or the person who is in the representative suit, the person who can make the admission and against whom it can be used. So the person who can make the admission, there you will find it joint interest, as a referee, or whose position has to be proved, or the person from whom one get the title, etc. And if it is a confession, then under the section 30, the confession by the co-accused, because the Jain and this LK Advani, VC Shukla, they are the co-accused in this case. So that can be proved. But here, if you observe the distinction between the admission and the confession, the admission is the grave incriminating fact, and the confession is accepting or admitting the offense in itself, or all the facts that constitute the offense. Here the entries are not something that's showing admitting that they have done the this conspiracy or public corruption, or other things, or either they are not satisfied that this was with the intention or whatever the elements that constitute the offense, and in that light it is just an admission. Now if you see from section 17 to 23, you will not find anything that admission can be used with the co-accused against the co-accused also. But when you come to the admission, confession, from section 24 onward, in the section 30, where the Kashmira Singh case is very famous case, that the confession can be used. The latter part of this para number 53, that chapter 14 of CRPC. Secondly, a statement made by an accused is admissible against other who are being jointly tried with him only if the statement amount to the confession. Where the statement falls short of the confession, it is admissible only against its maker as an admission and not against who are being jointly tried with him. And therefore, from the point of view of section 30 of the Evidence Act, also the distinction between admission and confession is of a fundamental importance. There on the para number 53, para number 53, there is this Ramjet Malani. After that, there is one quoted para started last from this page to the running this. In the last of this para, you will find certain lines in the italic. That it's very important, because if it is a confession, it can be used against the co-accused who is tried with them. But if the statement fall short of the confession and it is just only the admission, then it cannot be used. Now, if you see these statements, these entries in the Jain diaries, they are not the confession, because they have not admitted the offense in itself, or admitting all the facts that constitute the offense. But certainly these are the admission, because they admit that certain amount of the money was flown or was paid to the VC Shukla and LK Advani, where that is written in the diary. And so these statements are just the admissions. And as said, that if it is the admission, it cannot be proved against the co-accused. So these statements cannot be proved against the VC Shukla and the LK Advani. Only against the Jain brother they can be used. And in the para number 55, you will find using this thing. And then, later on it says that these statements as such cannot be used. And so, yeah. However, as against the Jain, the statement may be proved as admission with section 21, provided they relate to and the fact in issue or relevant fact. Needless to say that what will be the fact in issue or relevant fact will depend and will be delineated the nature of the accusation. And on the para number 60, before we conclude, it is need to be mentioned that another question of considerable importance came up for these appeal was whether the member of the parliament come within the public servant, etc. So I'm leaving these lines. Then the assumption that they could be prima facie made any of the respondent justify. Yeah, we did not deem it necessary to go into the question, as we found, proceeding on the assumption that they could be prosecuted, that no prima facie case was made out against any of the respondent to justify the charges were framed against the Jain and the Shukla in one case, and were framed against the Jain and Sri Advani in the another case. So against the these persons, no case is made out, because these statement cannot be proved under section 10 to show the conspiracy. It cannot be proved under section 34. It cannot be proved under the confession, because they are just in the admission, and so it can be used against these persons. When you prove against the Jain, so the conspiracy part you cannot show, and when the conspiracy part and that you cannot show, so the chain of the prosecution would not complete, and so it's not proper to. The another question that was posed, that whether the office of the parliament or member of parliament is the office of public servant or not, so that has not been decided by Supreme Court. कि जब केस ही नहीं हो पा रहा evidences पे, so it's not proper to decide that. And so these accused was the charges were quashed as directed by the Supreme Court, because the appeal was allowed. Appeal was dismissed by the central CBI. Okay. हाई कोर्ट ने जो ऑर्डर पास किया था सेम हैज बीन पास्ड बाय द सुप्रीम कोर्ट. So this is the end of this case. Now the Veera Ibrahim versus State of Maharashtra, but this case is on the section 24. So section 24 we will discuss in the next class, and on that section we will discuss this Veera Ibrahim versus State of Maharashtra. Section 24 is with regarding to the confession. As such, you I think now aware that confession is something where a person admit the accused in itself or admit all the facts that constitute the offense. So that is confession. Section 24 talk about that confession that is from the threat, promise or inducement for and this threat, promise and inducement by the person who is in the authority. So in that case it cannot be used. Like कई बार पुलिस ऑफिसर कहता है ना, आप अपना जो है ऑफेंस स्वीकार कर लो, एडमिट कर लो, कन्फेशन दे दो, आपको सजा कम करवा देंगे. सो दिस इज समथिंग प्रॉमिस, और इंड्यूस करते हो या थ्रेट देते हो या आपके घर वालों को मार देंगे या ये कर देंगे. सो दैट टू दैट पार्ट सेक्शन 24 of the Indian Evidence Act is dealing. So with this the today class is over. Now if you have any question, query, you can ask me. The three cases that we have discussed, the first case was Jayantibhai Bhenkerbhai versus State of Gujarat. The second case was Dwarka Bishwanath Prasad, and the third case was the CBI versus VC Shukla. And the various things that related to these cases also we have discussed. If you have anything, you can ask me. I'm just giving you 2 minutes.